Very good day to everyone. Today we are going to continue with the next topic, which is the consideration in contract law. So first, let's remember this key rule. A contract can only be enforced if it is supported by consideration. This means a promise alone is not enough. Something must be given in return. According to Section 2D of the Contract Act, consideration exists when at the desire of the promiser, the promisee or any other person does something, gives something, or promises to do something. In simple words, consideration means giving something in return for a promise. This section tells us that the promisee must give something back for the promise made by the promiser. A promise itself can also be consideration. The consideration must have value in the eye of the law. Consideration is like a price paid for a promise or an act by the other party. Without consideration, there is no valid contract. So remember, when there is no consideration, means there is no enforceable contract. And each party must give or promise something valuable in return. Now let's look at the meaning of consideration under the common law as explained in the case of Curie versus Misa. So in this case, consideration is defined as a benefit and also a detriment. So what is a benefit? Benefit such as a right, interest, profit, or advantage received by one party. A detriment means loss, responsibility, or giving up something that is suffered by the other party. In simple words, consideration exists when one party gets a benefit and the other party gives something up or suffers a loss. Both do not need to gain something. It is enough if one gains a benefit and the other suffers a detriment. This definition supports the idea that a contract is fair because there is an exchange between the party. So remember, consideration can be a benefit or a detriment, and there must be an exchange between the party. Now, we move to the first category of consideration, which is known as the executory consideration. Executory consideration means a promise made in return for another promise. In this situation, both parties have promised to do something, but neither party has performed the act yet. According to Section 24, this type of consideration is lawful as long as the promises are valid under the law. So, executory consideration exists when one party promises to do something in the future and the other party also makes a promise in return. At this stage, it is promise versus promise. So let's look at the simple example given in the slides. A agrees to sell a house to B for 100,000. B promises to pay 100,000 later. A promises to transfer the house later. So here, B promised to pay is the consideration for A promise to sell. Next, A promise to sell is the consideration for B promise to pay. So both promises are lawful consideration, and this is what we call as executory consideration. So please remember that executory consideration means promise for a promise, and the actions are not yet completed. Let's look at a case, K. Murugeshu versus Nadaraja. The fact of the case is that in this case, the respondent was a tenant of the appellant. The appellant agreed to sell the property. The respondent agreed to buy the property. The agreement was written on a piece of paper. Later, the appellant refused to sell. The respondent then suffered for a specific performance. So the discussions of the court held that this agreement was a case of executory consideration. Why? Because one party made a promise to sell and the other party made a promise to buy. So each promise was made in return for the other promise. Therefore, each promise became the consideration for the other. This is a clear example of promise for a promise, which is executory consideration. So a key point for you to remember here, executory consideration means promise in return for a promise, and each party's promise is valid consideration for the other. Now, we move to the second category of consideration, which is called the executed consideration. Executed consideration happens when an act is done in return for a promise. This means one party has already performed the act, and that act is the consideration for the promise made by the other party. A common example of executed consideration is a reward for doing an act. Once the act is completed according to the offer, the consideration is considered executed. However, the person who made the promise must still fulfill the promise. Here we have an example. A offers a reward of 5,000 to anyone who returns the lost gold ring. B finds the ring and returns it to A. B's consideration is that he returned the lost ring, which the act already done. Now, it's A obligation to pay 5,000 to B. If you look at this example, B has already performed the act by returning the lost ring. So the consideration is executed and A must pay the 5,000. So for you to remember here, executed consideration means act done for a promise. The act is already completed and the promiser must still honor the promise. Now let's look at an important case related to executed consideration, which is Carlyle versus Carbolic Smoke Ball Company. In this case, the defendant company made a general offer to the public. They promised to pay money to anyone who used their product as instructed and still became ill. When Mrs. Carlyle used the product exactly as stated and fulfilled all the conditions, the court held that the consideration was executed. This means once the promisee fulfills the conditions of the offer, the condition is complete and the contract becomes legally binding. So there is no further negotiation is needed. Doing the required act is enough to form the contract. So let's look at the third category of consideration, which is known as the past consideration. Past consideration refers to something that is already done before the promise is made. This means the act was completed first. The promise was made afterwards. The act was not done in return for the promise. In simple words, the promise comes after the act, not before it, because the act was not done in response to the promise. Past consideration is generally not valid considerations under common law. So a simple example to you, let's say Ali helps Budi to repair his house without any promise of payment. After the house is repaired, Budi says, I promise to pay you 500 ringgit for helping me. The repair work was done before the promise. The promise came later. So this is what we call as past consideration, and the promise is not enforceable. Okay, so for you to remember here is that past consideration is an act done before the promise. The promise is subsequent to the act, and usually no valid consideration is needed here. Let's continue. Now, let's look at an example of past consideration under section 26, okay, illustration C. Now, in this situation, A was involved in a road accident. B happened to be passing by and saved A's life. After being rescued, A promised to give B 1,000 ringgit as a reward. The important point here is timing. B saved A's life before any promise was made. The act of saving A was done voluntarily, not because A promised any reward. The promise to pay 1,000 was made after the act was already completed. Therefore, the act of saving A's life is past consideration because the act was not done in return for the promise. The promise to pay 1,000 is not enforceable. So a key point for you to remember here is that past consideration means act completed before the promise. Promise comes after the act, and generally not valid consideration. Earlier, we learned that past consideration is generally not valid, right? However, under Section 2D of the Contract Act, Malaysia takes a different approach. Section 2D uses the word has done or abstained from doing. This phrase shows that an act done before a promise can still be valid consideration. But there is one important condition. The act must be done at the desire of the promiser. If the act was done because the promiser requested it, then even though the act happened before the promise, it can still be a valid consideration. So in Malaysia, past consideration can be valid only if it was done at the request or desire of the promiser. Okay, so please remember everyone that past consideration is valid if done at the desire of the promiser. Section 2D allows act done before the promise, and the request by the promiser is the key factor. Now let's look at an important case on past consideration, which is lamb plague versus Braithwaite. Now, fact of the case, in this case, B was sentenced to death. B requested L to do everything possible to obtain a pardon. L worked hard and successfully obtained a pardon for B. After that, B promised to pay £100 to L. However, B later refused to pay. L then sued B. B argued that there was no consideration because the act was already done. So the decisions of the court held that L was entitled to the payment. Why? Although the act was done before the promise, the act was done at the request of B. The court said the previous request by B and the later promise to pay should be treated as one single transaction. Therefore, this was valid past consideration and the promise was enforceable. So simple explanation for you to understand is that if an act is done at the request of the promiser and later the promiser promises to pay, the consideration is valid. Okay, so let's continue with the next case, Keppong Prospecting Limited versus A. East Schmidt. This is another important case on past consideration. So the fact of the case, in this case, Schmidt was a consulting engineer. He helped Mr. X obtain a mining prospecting permit in Johor. He also helped in forming Keppong Prospecting Limited. After the company was formed, Schmidt was made a managing director. The company later agreed to pay Schmidt 1% of the value of all ore sold. This payment was said to be for services done before incorporation, services done after incorporation but before the agreement, and any future services. So this issue was later the services done before the agreement was made, which were clearly past services, could amount to valid consideration. The decisions of the court held that Schmidt's services, although past, were valid consideration. The services were done with the understanding that he would be rewarded later. Therefore, the promise to pay 1% was enforceable. This shows that past considerations can be valid if it forms part of the same transaction and was expected to be paid. So simple explanation for you is that past services can be valid consideration if the services were done with an understanding of payment and later confirmed by a promise or agreement. Now let's look at the general rule for consideration. Under Section 26 of the Contract Act, an agreement without consideration is void. This means if one party makes a promise without receiving anything in return, the agreement has no legal effect. In law, a promise must be supported by consideration to be enforceable. A mere promise or gift is not enough. So an illustration for you under Sections 26, A promises to give B 1,000, but B gives nothing in return. There is no consideration from B, so the agreement is void and B cannot enforce the promise. So remember, an agreement without consideration is a void agreement. A promise must be supported by something in return. This is the general rule under Section 26. Earlier, we learned that general rule under Section 26 says that an agreement without consideration is void, right? However, Section 26 also provided exceptions to this rule. There are 4 exceptions under Section 26. Under these exceptions, a contract can still be valid and binding, even though no consideration is present. This means that lack of consideration does not always make an agreement void. The law recognizes that in certain situations, fairness and intentions are more important than consideration. So we are going to study each of these 4 exceptions separately with example and cases to help you understand better. So here, exceptions to consideration under natural love and affection. Under Section 26A of Contract Act. Normally, an agreement without consideration is void. However, in Section 26A provides an exception. An agreement without considerations can be valid if it is made on an account of natural love and affection. But this exception only applies if all these conditions are fulfilled. What are they? First, for a contract based on natural love and affection to be valid, number 1, the agreement must be in writing. Number 2, the agreement must be registered if registration is required by law. Number 3, agreement must be made between parties standing in near relation. Number 4, the agreement must be made because of natural love and affection. If any one of these conditions is missing, then the agreement is not valid. Registration is not necessary if there is no law requiring it. Let's look at Ri Tan So Sim. This is a case. Let's look at the fact of this case. Tan So Sim was very ill and near death. She could not make a will. So her sister signed a document renouncing their rights to Tan's estate. The intention was to divide the estate among Tan's adopted children. The legal issue here is that was the agreement valid under Section 26A as one made out of natural love and affection? The decisions of the court held that the agreement was not valid. Why? Because under Chinese custom, adopted children are in near relation only with their foster parents, not with the foster parents' family, which is the sister in this case. Therefore, the requirement of near relation was missing. So if either the relationship or love and affection is lacking, then Section 26A does not apply. So a key point for you to remember here is that agreement without consideration is void unless Section 26A applies. And under 26A says that it must be written, must involve near relation, must based on natural love and affection. Missing one of these elements will result in invalid contract. Next, let's look at the exceptions of consideration, the Pass Voluntarily Act. Under Section 26B, the first limb, normally an agreement without consideration is void. However, Section 26B, first limb, provides an exception. Under this exception, a promise can be valid even without consideration. If it is a promise to compensate a person who has already voluntarily done something for the promiser. Now, condition under Section 26B, first limb. There are two conditions that must be fulfilled. Number one, there must be a promise to compensate the promisee. The act must have been done voluntarily by the promisee for the promisor. So if both conditions are satisfied, the agreement is valid even though there is no consideration. This means the act is done first. It is done voluntarily and later the promiser gives a promise to pay or reward. Even though the act is passed, the promise is still legally binding under Section 26B. Let's look at a simple example given in the slide. B voluntarily helps A repair his car during an emergency. Okay, this is an example. After that, A promises to pay B 300 for the help. Okay, the act was done voluntarily, and the promise is to compensate B. So this agreement is valid under Section 26B, even though there was no consideration at the start. Okay. Let's look at this case. J.M. Waterspoon and Company versus Henry Agency House. This is under Section 26B, first limb. Now let's look at the case. Plaintiff was an English firm. Defendant was a Malaysian firm. Both acted as agents in arranging sales. Defendant introduced buyers and plaintiff introduced sellers. Defendant normally received commission when sales were completed. However, a problem occurred when a buyer introduced by defendant failed to pay. So here, plaintiff suffered a loss. Defendant then promised to compensate plaintiff, but defendant later refused to pay. So the plaintiff sued the defendant. The issue was whether plaintiff had voluntarily done something for defendant so that the promise to compensate could fall under the exception of Section 26B. Now, the decisions of the court held that the promise was not enforceable. Why? The court explained that voluntarily means an act done by one's own free will, without being requested, suggested, or prompted by another person. So in this case, plaintiff acted on the suggestions of defendant. Therefore, plaintiff act was not voluntarily. Because the act was not voluntarily, so the promise to compensate did not fall under Section 26B. So simple explanation for you, if an act is done because someone suggested or requested it, it is not voluntarily, and Section 26B does not apply. Okay, so this is the case by J.M. Waterspoon versus Henry Agency House. Always remember that voluntarily here means done by free will, not prompted, not suggested, and not requested. Okay, if it is not voluntarily, then Section 26B fails. Now, let's look at Section 26B, second limb. Okay. Now, normally, again, like we have already said earlier, an agreement without consideration is void. However, Section 26B, the second limb, provides an exception. Under this provision, an agreement without consideration is valid if there is a promise to compensate a person who has voluntarily done an act and which the promiser was legally bound to do. So condition under 26B, the second limb, there are three conditions that must be fulfilled. Number one, there must be a promise to compensate wholly or partly. Number two, the act must have been done voluntarily by the promisee. Number three, the act done must be one which the promiser was legally compellable to do. So if all three conditions are present, the agreement is valid even without consideration. So let's look at an illustration on to section 26. Okay, here A supports B's infant son. B promises to repay A's expenses. So this is a contract. Okay, so the explanation here is that B is legally bound to maintain the infant. A voluntarily did what A voluntarily did what B was legally required to do. And B later promises to compensate A. Hence, the promise is binding. Okay. So in this particular slides, they're giving you a simple example. Here he says that Y was fined by the court and was legally required to pay the fine. X voluntarily pays the fine on behalf of Y. Later, Y promises to reimburse X. So here, the act was done voluntarily. The act was one Y was legally bound to do, and there is a promise to compensate. So this agreement is valid under section 26B, the second limb. So always remember that applies where the promiser had a legal duties. Promisee voluntarily performs that duty. Later, promise to compensate is binding, an exception to no consideration rule. Next, let's look at another exception to consideration. Here we are going to look at the contract to pay a statute barred debt under section 26C of the Contract Act. Now, in section 26C provides an important exception. Under this section, an agreement without consideration is still valid if it is a promise to pay a debt. The debt is already barred by limitation law, and the promise is in writing, and the promise is signed by the debtor. Such a promise becomes legally binding even though the creditor cannot sue for the debt anymore. Meaning, the meaning of statute barred debt. So a statute bar debt means the debt still exists, but the creditor cannot enforce it in court because the time limit to sue has expired. Okay, so conditions under section 26C, for the agreement to be valid, all conditions must be fulfilled. Okay, what are the conditions? Number one, there must be promise to pay wholly or partly. Number two, the promise must be in writing. And then number three, the promise must be signed by the person to be charged. And number four, the debt must be one that was legally enforceable before the limitation period expired. So if any condition is missing, the agreement is void. So let's look at the illustration to section 26E. I'm sorry, under this section 26. Okay, explanation on the exceptions of statute barred debt. Here, he illustrates that A owes B 1,000, but the debt is barred by limitation. A signs a written promise to pay B Rm 500 on account of the debt, and this is a contract. So in this situation, A originally owed B 1,000 ringgit. Due to the lapse of time, the debt became statute bar. This means B can no longer sue A in court. Later, A voluntarily signs a written promise to pay 500. So even though the original debt cannot be enforced by law, there is no new consideration. The law says the agreement is still valid. Why? Because the promise is in writing, the promise is signed, and it is a promise to pay a statute barred debt, wholly or in part. This falls directly under Section 26C. So let's look at Section 26C in more detail, especially the conditions that must be fulfilled. This section deals with a promise to pay a statute bar debt. Normally, once a debt is statute bar, the creditor cannot sue to recover it. However, Section 26C allows such a promise to be legally binding, even without consideration, if certain conditions are met. So the conditions under Section 26C says that there are two main conditions. Number one, the debtor must make a fresh promise to pay the statute bar debt, either wholly or partly. The promise must be in writing and signed by the debtor or the debtor's authorized agent. So if the promise is only verbal, it is not valid. So here there's an example from the slide. A says to B, I know I still owe you 1,000, which I borrowed 7 years ago. I shall pay within 2 months. This promise will only be valid if it is put in writing and it is signed by A. Without writing or signature, the promise is not enforceable. Okay. Time limit for contract action. This is the limitations law. Under the Limitation Ordinance 1953 of Peninsular Malaysia, the time limit to sue in contract is 6 years. The time begins from when the cause of action arises. If more than 6 years have passed, the action becomes statute bar. The creditor cannot sue to recover the debt. However, a new written and signed promise revives the enforceability under Section 26C. Okay, so I give you a simple example here. A borrowed 5,000 from Abu 8 years ago. Okay, now Abu can no longer sue because the debt is statute bar. It's more than 6 years, right? So later, A signs a document promising to pay 2,000. So now the promise is fresh and it is in writing and signed, and it relates to the statute bar debt. So this is a valid contract under Section 26. So a point for you to remember here is that debt is barred after 6 years. Creditor cannot sue after the limitation period. Fresh promise must be written and signed. Promise may be full or partial payment. And this is exception under 26C. Thank you very much for your attention, and I'll see you guys again on our next topic. Thank you.